Stranded alone at sea, with absolutely no food or drinking water, four men are fighting for their lives. One is gravely ill, shifting in and out of consciousness. Another will soon be in his position if they are not rescued soon, due to severe dehydration. In what is the ultimate last resort, one of the healthier men slaughters the sick younger boy, so that he and the surviving seamen may feast on his body and live. While some, if not most of you, may have clicked off of this video due to its grotesque nature, I applaud those of you that chose to stay. The case of R. v. Dudley and Stephens is a pinnacle of English law and is considered a great case internationally. The title of this video is apt. This case genuinely considered whether there is ever a legal opportunity to eat someone. This title is based on a book by Professor Alan Hutchinson, which I highly recommend. Furthermore, R. v. Dudley and Stephens questions defenses to murder that are still debated to this day. The men, Park, Dudley, Stephens, and Brooke, were aboard the Mignonette yacht when a storm suddenly launched waves aboard the boat. Dudley, the captain of the Mignonette, quickly regretted his decision not to splurge on ship upgrades. The four men frantically made their way aboard a small, dingy lifeboat with only 2 cans of turnips and 0 drinking water. After one night, the four split the can of turnips. However, over the next few nights, the food situation would deteriorate even more. There was absolutely no indication that help was on the way. They were away from common trading routes, meaning it was unlikely that any boats would be near them anytime soon. One thing you need to understand about this case is the circumstances and societally accepted law at the time. Though not officially documented in English law, it was typical that if men were stranded at sea with grim prospects of surviving, a lottery would be conducted, and the man who drew the short straw would be killed and eaten to save the remaining men. It was thought that one man's sacrifice, if it saved other men, was socially acceptable. In fact, we will see that there was tremendous support for the men who killed aboard the lifeboat. Back to our story. With no indication that there were going to be any survivors, Dudley suggested they do a lottery to determine who would sacrifice himself. However, all four men could not come to agree that this was the correct course of action. As the nights went by, Parker began to become extremely ill. He was losing consciousness and becoming even more severely dehydrated due to stomach conditions from drinking seawater. Dudley was relatively quick to point out that Parker was, in his opinion, the obvious pick for any sacrifice for the greater good of the other 3 men. He decided, if another night went by with no indication of another ship, he would kill Parker. Stephens was in agreement with Dudley, though Brooks sat at the far end of the ship and refused to speak neither for or against killing Parker. The night came and went. Dudley, thinking he was only speeding up the natural progression of Parker's fate, slit Parker's neck. This is graphic, so fair warning, please skip ahead about 30 seconds to avoid the graphic description. The men were so dehydrated, they then began to drink Parker's bodily fluids before feasting on his internal organs. When the remaining 3 seamen were finally rescued by a cargo ship and returned to land, they were praised as heroic survivors. The public did not give much thought to Parker's killing because, as I mentioned, what the men did was customary at the time. The crux of the case is as follows. Just because something is customary and generally socially acceptable, is it legal? Additionally, is necessity ever an excuse for murder? This case would be heard by the highest court in England, the High Court of Justice, to decide these questions. During the trial, held before Baron Huddleston, Arthur Childs, QC, led the prosecution and Arthur J.H. Collins led the defense. Huddleston was staunch in his opinion that the men had no excuse for their cannibalistic actions, and he had decided a guilty verdict would be announced before the defense had an opportunity to state opening arguments. The jury, aware of the circumstances of Parker's death and the dire conditions that led to Dudley's and Stephens' actions, chose to return a special verdict. A special verdict is one that merely restates the facts of the case but does not state an opinion regarding whether the parties involved are innocent, guilty, or otherwise. The special verdict reads that if the men had not fed upon the body of the boy, they would probably not have survived to be so picked up and rescued, but would, within the 4 days, have died of famine. That the boy, being in a much weaker condition, was likely to have died before them. That at the time of the act in question, there was no sail in sight, not any reasonable prospect of relief. That under these circumstances, there appeared to the prisoners every probability that unless they then fed or very soon fed upon the boy, or one of themselves, they would die of starvation. That there was no appreciable chance of saving life except by killing someone for the others to eat. That assuming any necessity to kill anybody, there was no greater necessity for killing the boy than any of the other 3 men. An expanded bench was formed, consisting of 5 judges. Charles, arguing for the prosecution, relied heavily on legal precedent, citing the Merchant Shipping Act of 1854, before calling Brooks to the stand for testimony. Brooks provided a detailed account of Parker's murder and the subsequent cannibalism of his body. Collins, in his closing statement, preached about the defense of necessity. This defense argues that suspects cannot be found guilty of murder if they only committed the act or omission out of necessity. However, the final words of the verdict read, "But whether upon the whole matter the prisoners were and are guilty of murder, the jury are ignorant and referred to the court." Brooks and Stephens were initially sentenced to life in prison and the death penalty, but later, by recommendation of innocence, had their sentence reduced to 6 months in prison. The judges found that the defense of necessity had no basis, legally nor morally. To quote the judgment, "To preserve one's life is generally speaking a duty, but it may be the plainest and the highest duty to sacrifice it. War is full of instances in which it is a man's duty not to live, but to die. The duty, in case of shipwreck, of a captain to his crew, of the crew to the passengers, of soldiers to women and children, as in the noble case of the Birkenhead. These duties impose on men the moral necessity, not of the preservation, but of the sacrifice of their lives for others, from which in no country, least of all, it is hoped, in England, will men ever shrink, as indeed they have not shrunk." Another statement reads, "It must not be supposed that in refusing to admit temptation to be an excuse for crime, it is forgotten how terrible the temptation was, how awful the suffering, how hard in such trials to keep the judgment straight and the conduct pure. We are often compelled to set up standards we cannot reach ourselves, and to lay down rules which we could not ourselves satisfy. But a man has no right to declare temptation to be an excuse, though he might himself have yielded to it, nor allow compassion for the criminal to change or weaken in any manner the legal definition of the crime." What do you think? Were Dudley and Stephens in the right? Thanks for watching.